Hello, and welcome to the Ministry of Government Relations four-part webinar series on development appeals. This series provides important information on development appeals processes and procedures. This video is part 2 of the series, which lays out an applicant's right of appeal, the different types of appeal, and the procedures for giving proper public notice. The content of this webinar series is based on the Development Appeals Board guide on Saskatchewan.ca. This guide includes several samples, checklists, and flowcharts to help make the development appeals process as simple as possible. To access the guide, search Development Appeals Board Guide on Saskatchewan.ca. In this webinar, we will examine the applicant's right of appeal on zoning matters and the different types of appeals allowed under the Act, the applicant's right of appeal on applications to subdivide land, the contents of an application for appeal and the timelines for submitting information, the procedure for providing notice of the appeal hearing on zoning matters, and the procedure for providing notice of the appeal hearing regarding the subdivision of land. Once a zoning bylaw has been adopted by a municipality, residents of the municipality are granted certain rights of appeal on provisions of the zoning bylaw. The first type of appeal is an alleged misapplication of the zoning bylaw in the issuance of a development permit. For example, say the development officer has issued a permit for the house shown on the screen. The proposed house is on a corner lot, and the site plan with the development permit shows it being placed 6 meters from Smith Street and 2 meters from First Avenue. The zoning bylaw defines Smith Street as the front sight line of the lot, making the First Avenue property line the side property line. In this example, a neighboring property owner or other affected person may appeal the issuance of the development permit on the grounds that the proposal does not meet the requirements of the zoning bylaw. The Development Appeals Board is likely to determine in this case that the development officer has erred in the issuance of the permit since the house location does not meet the minimum required setback of 3 meters on the First Avenue side. If so, the board may then issue their decision that the development permit is invalid. The term affected person appears in this section of the Act to recognize that, in some cases, neighboring property owners may be impacted by a development decision. It is the responsibility of the affected person to demonstrate to the board how they may be affected by the proposal. It is then the role of the board to determine whether this person truly has jurisdiction to file an appeal as an affected person. In some cases, the person appealing may not have a strong enough argument to demonstrate that they should be granted affected person status for the purposes of the appeal. The board may be challenged on its jurisdiction to hear any appeal where the appellant does not qualify as an affected person. More information on jurisdictional challenges can be found in Part 3 of this webinar series. The second type of appeal is the refusal of a permit because it would contravene the zoning bylaw. Using our example from the last slide, in this scenario, the development officer has refused the permit due to the proposal not meeting the 3-meter minimum side yard setback. The applicant for this proposed house may appeal the refusal to the Development Appeals Board and request that a variance be granted to the zoning requirement. The board may grant variances to any development standard with a special circumstance that would make complying with the requirement unnecessary or impose undue hardship. For the board's consideration, let's say that the applicant supplies evidence that a natural gas line prevents them from moving the house over to meet the minimum 3-meter requirement. The board may consider whether this constitutes a special circumstance and whether they will grant a variance to the setback. If, after considering the criteria in the Act, they determine that this is an acceptable special circumstance, they may direct that the permit be issued at the 2-meter setback. If, instead, they determine that the circumstance is not enough to warrant a variance, they may uphold the permit refusal, and the applicant must then examine other options to meet the requirements, such as making the house narrower or requesting that the utility company relocate the gas line. It is important to note that there is no right of appeal where the proposed use of the land is not listed as permitted or discretionary in the zoning district, since that would be a land use decision reserved solely for municipal councils. The board may only grant variances to development standards and conditions. Using this example, if the development permit was refused on the basis that houses are not permitted or discretionary in that zoning district, then the board would not have jurisdiction to hear an appeal on the permit refusal. The third type of appeal is an order to remedy a contravention of the zoning bylaw. If the development officer has been made aware that development has taken place in contravention of a provision of the zoning bylaw, they may issue an order to the landowner requiring that they remedy the contravention in accordance with Section 242 of the Act. The development officer may inspect the property for themselves, subject to landowner permission, and take pictures of the contravention to be used in the appeal or any future court proceedings. In the order, the development officer must specify the contravention, the proposed remedy, such as discontinuing the development or altering the development to comply with the zoning bylaw, the time by which the landowner must comply with the order, and shall advise them of the right to appeal the order to the Development Appeals Board. Keep in mind that there is no right of appeal on the use of land. In this instance, if the development is not a permitted or discretionary land use in the zoning district, the appeals board would not have jurisdiction to allow the use to remain there. The fourth type of appeal is regarding the standards or conditions imposed for a discretionary use. Applications for a discretionary use must be reviewed using the criteria outlined in the zoning bylaw. Where council or the development officer determines that the proposed use meets the criteria in the bylaw, they may approve the application or approve it subject to development standards or conditions. Those conditions must be based on requirements contained in the zoning bylaw and must be necessary to secure the objectives outlined in the bylaw. In cases where council or the development officer has assigned standards that do not align with the requirements of the bylaw, the applicant may appeal those standards to the board. For example, if the approval requires that the applicant landscape the property a certain way or meet architectural requirements not outlined in the zoning bylaw, that may be considered excessive and may be appealed to the Development Appeals Board for review. Keep in mind that there is no right of appeal where council or the development officer has denied the discretionary use application, since that would be a land use matter. The fifth type of appeal is the refusal of council to remove the holding symbol from a property. A municipality may use a holding symbol, often shown as an H after the primary zoning district, to indicate that there are requirements that must be addressed before the land can be used. Holding symbols are typically used when servicing capacity or other factors must be addressed before the land may be developed. The holding provision is a way for the municipality to pre-zone land to provide landowners certainty, without losing the ability to ensure certain conditions are met prior to development. If the landowner applies to have the holding symbol removed from their land and council refuses the application, they may appeal that refusal to the board. The landowner may also appeal if the application to remove the symbol has not been dealt with within 60 days. As part of the appeal, the landowner may need to provide evidence that the holding symbol is no longer necessary. For example, where services have been upgraded to accommodate the development of the site or engineering studies have been undertaken to prove the land is suitable for development. Alternatively, council would need to defend their refusal by providing evidence that further action is required to make the land developable. The sixth category of appeal is regarding decisions pursuant to interim development control bylaws. In cases where a municipality is in the process of developing a new official community plan and zoning bylaw, but requires some form of planning controls while those bylaws are being developed, the Act allows for the adoption of an interim development control bylaw. An interim development control bylaw may also be passed while the municipality studies a land use matter or prepares an amendment to existing planning bylaws. Interim development control bylaws allow council to assign development standards or conditions with the approval of a development permit. In those cases, the applicant may appeal the standards to ensure that they are reasonable and necessary. An applicant may also appeal within 30 days if their application is refused, or after 60 days if their application is not dealt with in that time. If the municipality does not have a zoning bylaw, the appeal is made to the provincial Saskatchewan Municipal Board. If the municipality has a zoning bylaw, the appeal must be made to the local Development Appeals Board. The seventh category of appeal is related to decisions on minor variances. New zoning bylaws are required to contain sections on minor variance procedures. The term minor variance refers to the ability of the development officer to vary the proposed distance between buildings or between buildings and property lines by up to 10% of the requirement. There are three situations where minor variance decisions may be appealed. 1. If the application for a minor variance is refused by the development officer, the applicant may appeal the refusal to the Development Appeals Board. The board would examine the reasons for refusal and may grant the variance request if they deem it to meet the requirements of the Act and zoning bylaw. 2. If the application is revoked by the development officer, the applicant may appeal the revocation to the board. During the required public notice process for granting a minor variance, if one of the neighboring property owners objects to the granting of the variance, the approval is revoked. If appealed, the board will consider the neighbor's concerns to determine whether they are truly injuriously impacted by the variance. 3. If the application is approved with development standards or conditions, the applicant may appeal those standards to the board. The standards imposed must be consistent with the requirements in the zoning bylaw, and if they are not, the board may direct that the standards be altered to what is in the zoning bylaw or remove them entirely. The eighth type of appeal is on the development standards respecting site plan controls for commercial, industrial, institutional, and mixed-use developments. If an approving authority has policies in their official community plan respecting site plan controls, then in a zoning bylaw, they may apply specific standards related to traffic operations and access to public streets to and from the site, the circulation of traffic within a site, the placement of buildings and other structures within a site, and the placement of landscaping within a site. The standards applied must align with the zoning bylaw. An applicant may appeal the development standards or conditions to the Development Appeals Board if they believe them to be unnecessary or exceed what is necessary to secure the objectives of the zoning bylaw. The ninth category of appeal relates to decisions in special zoning districts. The Act authorizes the creation of special zoning designations used in conjunction with another zoning district to further control development in specific areas to achieve municipal goals. These include direct control districts, demolition control districts, and architectural control districts. From a high level, direct control districts allow council to have more control over development in an area than any other general zoning district. Permits in direct control districts often require the signing of development agreements to assign development-specific regulations. Demolition control districts allow council more control over the demolition of residential buildings within an area. Architectural control districts allow council more control over the architecture and appearance of buildings in an area. If development permits in these districts are refused or approved subject to standards or conditions, those may be appealed to the local board. There are also time limit requirements for making decisions in these districts. If decisions are not made within these timelines, the applicant may appeal the failure to make a decision to the board. The 10th right of appeal is the refusal of a permit for structural repairs, alterations, or additions to a non-conforming building. If, in the enactment of a zoning bylaw or amendment, a building no longer meets the development standards, that building may remain a legal, non-conforming building. Structural repairs, alterations, or additions may be made to the non-conforming building if they comply with the current zoning bylaw in effect. If a permit for these items is refused, the applicant may appeal to the local Development Appeals Board. The board may grant a variance to a non-conforming building if it meets the requirements of the Act or upholds that any changes to the building meet the current bylaw in effect. The 11th type of appeal is unique to northern municipalities. Under the Northern Municipalities Act, if council issues an order to repair or demolish a derelict building, that order may be appealed to the local Development Appeals Board if established. There may be several opportunities for appeal during the review of a subdivision application. In most cases, subdivision appeals are made to the Saskatchewan Municipal Board unless the municipality is a subdivision approving authority, in which case they must be appealed to the local Development Appeals Board first. The situations where a right of appeal exists for subdivision includes refusal of an application for subdivision approval, approval in part of an application for subdivision approval, approval is subject to development standards, revocation of an approval, failure to enter into a servicing agreement within the time period specified, either 90 days or a period mutually agreed to by the municipality and applicant. An applicant's objection to providing any additional information requested by the approving authority, the terms and conditions of a servicing agreement or whether one is necessary, or the request for payment of a development levy or servicing agreement fee outside of what is included in any agreement. The appeal application may be in any written format deemed acceptable by the local board if it contains a minimum of the following information: the reason for the appeal, a summary of the supporting facts, the relief sought, such as a variance or the alteration of terms or conditions of a permit, and the prescribed fee not exceeding $300. The applicant may provide any additional supporting information for their appeal no later than 5 days before the hearing date. This may include maps, plans, and written materials for the board's consideration. Within the same deadline, the council or designated representative shall submit original or true copies of all documents in its possession relating to the appeal's subject matter. All documents submitted by any party must be made publicly available and form part of the public record for the appeal. Once the board receives a completed appeal application, they are obligated under the Act to hold an appeal hearing within 30 days. If the board has regularly scheduled meetings, for example, once a month, then they may wait until their next scheduled meeting to hold a hearing for the appeal. The Secretary of the Development Appeals Board is responsible for sending out all public notices on behalf of the board. No later than 10 days before the appeal hearing, the board shall give notice to the appellant, the landowner, if not the same as the appellant, the council of the municipality, in the case of a subdivision appeal, the approving authority, all property owners within 75 meters of the boundaries of the subject property, and any other owners required to be notified by the zoning bylaw. As per the Act, notice may be given via personal service, ordinary mail, or registered mail. If notice is given via ordinary mail, the notice is deemed delivered on the 3rd day if the mailing address is within the municipality, and on the 4th day if it is outside of the municipality. The Secretary shall file with the board a statutory declaration stating the date that the notices were mailed, that the envelope was addressed correctly, and that proper postage was paid. If a municipality is a subdivision approving authority, the Local Development Appeals Board is responsible for hearing appeals on subdivision matters. Notice of appeal hearings for subdivisions have slightly different legislative requirements than zoning appeals. The Act requires that the board provide reasonable notice to the subdivision applicant, the approving authority, the municipality if different than the approving authority, and any other person the board considers to be affected by the proposed subdivision. The Act does not state the method that notice shall be given or what constitutes reasonable notice. It also does not specify how to determine an affected person. If the board is acting in good faith when making decisions regarding notice, it will reduce challenges to the board's procedure. For example, following similar notice processes as required for zoning appeals would be a reasonable, good faith approach. This concludes our second webinar in the Development Appeals series. To learn more about the Development Appeals process, view our other videos in this series, as shown on screen. If you have any questions related to the Development Appeals process, please contact the Community Planning Branch for assistance. The branch also offers in-person development appeal workshops that explore this content in more detail. Please contact the branch to arrange for a workshop in your area. Thanks for watching.